Filing of the petition. Under 2-118.1, you have 90 days. Again, we talked about that. If you don't file in 90 days, it's going to be barred. Now, in the event a petition is filed timely, but the motorist wants to voluntarily withdraw it pursuant to the statute 735 ILCS 5/13-217, the law permits under the McClure case that the refiling of this petition can occur within 1 year. So from the state's attorney's perspective, if the motorist files it within the 90 days, says, Judge, we're going to withdraw it, that doesn't cause a time that's required the state's attorney to get the case to a hearing under People v. Traynor, but rather is incumbent upon the motorist, if in fact they're ever going to refile it, to be done within 1 year. Keep in mind that these are unusual proceedings in that they are civil. And therefore, the civil standard of preponderance of the evidence controls. And again, I've talked about Traynor this morning. That is the leading case. It's a civil hearing, and it is a civil proceeding, and it is and in Illinois, the burden is on the motorist to initially take forth and present enough evidence to get past a motion for directed verdict. It's unusual. In Illinois, the motorist now has to show something under the statutory summary suspension hearing, and that burden of proof is set forth in the requirements in People v. Orth. We've referred to it previously. But Orth tells you the motorist has the burden of proving that the suspension should be rescinded. Once the motorist is done with their case, what you as a state's attorney should do then is file a motion for a directed finding, saying, Judge, even in the light most favorable to the motorist, they have not been able to sustain their burden. I will tell you that in most circumstances, if you make that motion from the state's attorney's perspective, it's going to be granted, because it is hard from the defense perspective to prove a negative, that the person was not under the influence of alcohol, the person was not doing anything wrong, or it wasn't over 08. So make sure at the conclusion of the defense case, the state's attorney or the local attorney files a motion for a directed verdict under People v. Hawkins and People v. Weiss. Let's move on and assume now that the judge has denied your motion to shift the burden, that the defense has presented enough viable evidence to proceed. Once that starts, then it's incumbent upon the court to try to move this case along to get it done. But if the case is started, if the hearing is started, that then tolls any requirement for having the case concluded within 30 days. So assuming that on day 30 the case proceeds, the defense is able to shift the burden, and you as a state's attorney must proceed, and you have a witness you need or you have some information you need, you can ask the judge to continue the case a reasonable amount of time to get that necessary proof of burden. And you cite People v. Cosenza at 215 Illinois 2nd 308, where Cosenza first held that the court is only required to start the hearing within the 30 days to satisfy the statute, and People v. Traynor. Cosenza also said then that once the burden shifts to the state, then the obligation is on the state to disprove by a preponderance of the evidence the allegations of the defendant's information, and may also then ask for a hearing to be continued to bring in evidence. Does that violate Traynor? No. The Cosenza case goes on to say they're going to trust judges to manage their court calls, their court dockets, and to get it done quickly. Continuing out for a year would not be reasonable. Again, what time is required, they didn't say. It's again up to the judge. Okay, what occurs when the motorist, in fact, testifies at the statutory summary suspension hearing? Some defense attorneys will call the motorist, some will not. If the motorist is called by the defense attorney, keep in mind then that the motorist cannot take the Fifth Amendment. Any incriminating testimony that comes out of that hearing from the defendant motorist's mouth can be used against them at the criminal proceeding. That is, if in fact the defense attorney calls the motorist. In People v. Hall, where the motorist was called by the state. In other words, the motorist proceeded by calling the police officer, the burden shifted, and then the state's attorney called the motorist, which they can do. Any incriminating testimony that the motorist would give when called by the state could not be used in the criminal proceeding. So my suggestion is that if in fact the motorist testifies voluntarily and in their hearing, that as the state's attorney, if there is a court reporter and the case proceeds to trial, before you proceed to trial, order up that transcript. Serve a copy upon the defense attorney, and then notify the court, file a motion in limine to have that evidence that the defendant testified to in their portion of the hearing to be used as substantive evidence against them at trial. And that proposition is People v. Snow, 403 Illinois App 3rd, 734. Here's what I suggest you don't do from the prosecution standpoint is, if you don't have a court reporter, do not attempt to call a fellow state's attorney or the clerk or someone else in the courtroom to try to testify as to substantive evidence or as rebuttal or impeachment at trial. It puts everyone in a very tough position, number one, and number two, it isn't a perfect record, because the perfect record would be the court reporter or the court transcript in those courthouses that have those that are recorded audibly in another part that are recorded without the court reporter there. Keep in mind, to summarize, this is important. The motorist testifies voluntarily at their hearing. Anything they can say, they do say, can be used against them in trial later. If the state's attorney calls them as a witness, it cannot be used against them at trial.